Good morning, everybody, and thanks for participating in today's webinar. Managing medical issues in the workplace is by far the most difficult personnel matter, issue, controversy that employers face right now. There's just so much law, so much statutory law. You know, it's statutory. It's the regulations that come out on these issues, the guidance from the EEOC and state human rights departments, such as, for example, the Illinois Human Rights Department. This is something that affects all employers. What we're focusing on today is really the triangle, if you will, between mandated leave law, mandated leave entitlements, rights, whether it is by a collective bargaining agreement providing leave entitlements, whether it's the law mandating leave entitlements, or whether it's a policy, a benevolent leave policy that the employer has provided to its workforce, and we want to make sure that we're not doing anything that undermines our credibility and our sense of fairness and the perception of equality under those benevolent policies. The next category is disability, and that I can go on the next slide here. I'm trying to navigate to the next slide. Let's see. Here it is. Okay. The next category, as you can see in the next slide, slide number 2, is disability and the disability law out there. Primarily, we're dealing with the Americans with Disabilities Act, as amended, because it's a different law than it was when it first was enacted back in the 1990s. Disability law on a federal level, disability law on a state level, and I'm primarily concerned with employers fumbling through the required interactive process. You want to put a gold star, you want to write down interactive process, which is just the legal jargon for sitting down and talking to an employee or by phone, communicating with an employee and determining what accommodations, if any, can the employer provide in order to continue the employment relationship. Those accommodations can include job modification, reassigning of job functions, job transfers, job transfer to another open position that the employee is qualified for, maybe even additional leave entitlements. And then the third category is work comp. And work comp is, it's making sure that we're administering, if it's work related, or if the reason why there's a medical issue is related, whether we agree, whether it's legit or illegit, I don't care. There's a claim that the medical issue deals with a work-related injury or illness. And that's another category that we need to deal with. So there's 3 main categories: the leave laws, the disability laws, and the work comp laws. It's a lot. That's a full-time, think about it. That's a full-time job for a lawyer, for a professional human resource manager to deal with each one. Not all 3, but just each one. Then you throw in other leave entitlements, the new pregnancy laws that's out there now, and pregnancy guidance through the EEOC on a federal level. There's local laws and state laws that could trip you up, that could be related to a medical condition, and employers need to note. What I'm going to go through today in the information and the discussion is really something that I don't care whether you're in California or you're in Illinois or you're in New York. What we're going to go through today has a universal appeal to it, has a universal application. And I think it's going to you're going to become more comfortable identifying potential problems and being able to identify maybe a policy or a practice that you've adapted or adopted over the years that might be troubling and might be out of strict compliance with the legal trends. All right, so managing. Okay, so there's some points that I want to make as we get into the meat of the material. First, your policies. Your policies need to define expectations as to leave rights, leave entitlements. What's really important is call in and call off rules. It sounds simple, but if somebody has a medical issue that's precluding them from getting to work on time or at all, or requiring them to leave early during the day, we should have call in and call off protocol and rules. And I don't care who you are. I don't care how protected you are. I don't care how serious the condition is. Absent some sort of exigent circumstance or emergency beyond the employee's reasonable control, they need to call in. They need to call off in strict compliance with very simple call in, call off rules. Don't lose sight of that. A lot of employers lose sight of simple call in and call off protocol, and you need to subject your employees, I don't care who they are, I don't care where they work, to these call in, call off rules. And then it becomes, you manage that rule. Supervisor knowledge and training. We want to avoid the supervisors putting their foot in their mouth. Supervisors saying something or doing something out of order, not running it through human resources, not running it through legal. Boy, I mean that's what pays my bills. I mean, I hate to say it, but supervisors messing up. If supervisors didn't mess up, I wouldn't have a job. Supervisors need to have an understanding, a knowledge, some basis to know. Don't say things about medical conditions. Don't use a medical condition or a medical absence against an employee in a review. Simple things. Don't throw in an email, Sam just reported another accident. This is Sam's 5th accident in the last 5 years. We need to fire Sam. That's low-hanging fruit for any bad lawyer, bad investigator to hammer an employer on. Third point that I want to emphasize is coordination, administration, and exhaustion of leave rights. And this is very important. Whether the leave if somebody's entitled to leave because of a medical issue, they're entitled to leave because of the medical issue. There's nothing we can do to avoid or evade or somehow interfere with an employer's with an employee's right to exhaust leave. If they have available leave under your policies, under your contracts, under the law, i.e. the family medical leave, you got to exhaust that leave. I always tell employers when they call me and say, we have a problem with Jim, we have a problem with Jane. What do we do with this medical issue? The first thing I'm going to say is, have you exhausted the medical leave entitlements, the leave entitlements? If you have not exhausted the leave entitlements, then short of them bringing a blowtorch to work and lighting up the someone's office, they're untouchable. You've got to exhaust those leave rights and entitlements and coordinate and administer that. Because think about it. You coordinate and administer and exhaust the leave entitlements, then when you get to the point where you take adverse action against Jim and Jane, weeks later, months later, maybe even years later, because you coordinated, administered, and exhausted the leave entitlements and rights, you're looking like a good employer. Why would you take adverse action against somebody after you've gone through the pains and the time and the commitment of ensuring that they have indeed utilize exhausted leave rights and other entitlements by policy or by law. And think about it, once you exhaust those leave entitlements, that's one less problem for you to up on. You don't want to ever be accused of interfering with someone's contractual rights or statutory rights for leave. You don't want to be accused of that. It's one less problem. It's one less headache. 4, consistent application of these rules, these rights, related policies. We want to make sure that we're applying the same rules, the same leave entitlements consistently amongst similarly situated employees. Employees in similar job classifications, categories, supervisors, locations. We don't want unequal treatment to rear its head. Number 5, document. If you don't, you know that. You've heard it from other lawyers, right? You don't document it properly. I like proper. I say proper. You hear the lawyers say document, document, document. No, don't document, document, document if it's all garbage. Document the good stuff. That is leave certification, leave designation, exhaustion of the leave right, as well as, and this is very important, gold star here, interactive accommodation process. You want to be able to not only document that you've exhausted leave rights and entitlements for medical issues, if the need arises, that they can't work, they can't be at work, but you also are documenting the employer, once those leave rights and entitlements are exhausted or as they're being exhausted, that the employer is reaching out and establishing an open communication with the employee, asking, when can you return? What accommodations do you need? We want to get you back to work. We want nothing more than see you return to active employment. We want nothing more than to work with you and get you through this issue so that you can go back and perform your regular full-time job functions. We want nothing more. Even if you don't mean it, that's how you communicate it, orally and in writing. You're gonna look good. Number 6, understanding use of reliance on independent medical examinations. Okay, you get an independent medical examination, sort of going through into the work comp exposure, right? Use an independent medical evaluation. That's going to tell you, can the employee return? What are the restrictions? What are the limits? Use it to your advantage. Use it to your advantage. Number 7, fair and consistent implementation of drug tests. Hey, I'm an advocate of drug testing. I'm an advocate of drug testing, especially post-accident. There's an accident. We define what accident means, right? You throw in a policy that we reserve the right to drug test following an accident. I don't know what that means. You have that language. Your supervisors and managers or local operations folks might not be consistent in implementing a drug test. What is indeed the definition of an accident you define as the employer to determine what's going to trigger the mandatory, you better comply, you need to consent, you need to comply with this process, and if you don't, you're subject to termination. Fair and consistent implementation of drug tests. That helps avoid future liabilities, reoccurring legal controversy, reoccurring work comp claims. It also reduces retaliation. If we are fairly and consistently implementing a drug test and we get somebody testing positive, I don't care if their arm was cut off and it's the employer's fault. Doesn't matter. If they test positive for an illegal substance, then we can take adverse action against that employee. Number 8, eliminating unlawful policies. All right, gold star moment, gold star moment. If you have anywhere written that an employee must be 100% healed in order to return to work without any restrictions, and that is something that you're mandating, that is per se illegal, unlawful. Many large corporations, name brand companies, have been sued over the last 10 years on this issue, and they've lost badly. You need to eliminate that type of policy. You need to eliminate that type of practice, because that that interferes with the ADAs and the state and local disability protections and the requirement to engage a worker who's not able to work but may be able to work with or without reasonable accommodation. You're eliminating the interactive process. You're also eliminating the interactive process, and it's per se illegal and unlawful, when you require termination, or you administer termination automatically upon the exhaustion of X period of leave. A lot of good companies, a lot of name brand companies, a lot of big corporations with fancy schmancy lawyers have been sued, especially over the last 5 to 10 years. In their policy, it said, hey, we'll give 2 years of leave. We'll give up to 3 years of leave. We'll give up to 1 year of leave. My goodness, aren't we good employers? But once you exhaust that 1 year or that 2 year or the 3 year, you're done. Can't do it, because that's a per se violation of the Americans with Disabilities Act. That is per se illegal and unlawful on a universal basis. And finally, just managing the Bermuda Triangle, prompt administration of work comp benefits. Boy, to avoid the perception of animus against the worker later on, you want to make sure that you have administered the work comp paperwork. You might not agree that it's work comp. You may think that the employee is making it all up. But that's for the work comp, that's for your third-party administrator to figure out and work on for you. That's for your work comp adjuster to work out and work with you on. That's for your defense attorney but through your work comp system. That's for her to work through and work on. You as the employer want to make sure that we administered the work comp. We processed it. Where it ultimately ends up, we don't know. We don't know. That's going to be resolved at the Work Comp Commission, the State Workers' Compensation Commission. But we're administering. What I don't want, and I'll give you an example. I'm defending a case, and it's a good case to defend, and it's a retaliation. The guy was on work comp. We exhausted leave. We interacted, and we came to the conclusion, hey, we don't have. You can't get back to work. It's been like a year and a half. We need to move on. We need to fill this position. We're ending this. We're ending this relationship. You're free to reapply when you're able and willing to come back. So the person was terminated, administratively separated from employment. He files a retaliation lawsuit. It's later, we had a slam dunk defense. What I didn't know, because the client never told me, is that they offered the employee, the worker, when he first reported work comp, cash under the table. We're not going to file work comp. You've got an unlimited amount of cash to make sure you get the treatment you need. And if you need something extra, I'm happy to pay you. I'm paraphrasing a little, but that's the gist of what happened. Well, that precludes dismissal, because we tried to buy off the work comp claim, that's inappropriate, by the way. You have to administer the work comp. So anything that we did to that worker is on the backdrop of some sort of animus. We must have had something wrong, something against that worker for bringing the work comp claim, because we didn't administer. That was enough to preclude dismissal. So gentle or not so gentle reminder. Purpose behind applicable law. FMLA, these mandated leave, whether state like California has state FMLA, Wisconsin has state FMLA, Connecticut has state FMLA, but there's also the federal FMLA, right? Whether it's state or federal or both, it protects the job. I can take medical leave. I can exhaust my medical leave rights under that leave law, and my job is protected at the expiration of that leave. The ADA, that purpose behind that law is to remove barriers to work, to force an employer, to require the employer to engage the worker in an interactive dialogue and communication to determine what can we do, what can we provide, what can we offer, what can tools, instruments, time off, more leave, job modification, restructuring, job transfer. If it's reasonable for us to do it, we need to do it. And when it becomes unreasonable, we're not going to do it. And we stop. And then we might have to administratively end the relationship. And work comp. Benefits to injured workers, we need to administer the work comp. We need to look at these three categories, the leave, the disability, and the work comp. We need to look at them in their own right through tunnel vision, but we also have to be mindful that they sort of bleed into each other. They mesh into each other. We have to have our eye on the switch at all times while we look at each category separately with a particular employee under a particular unique set of facts. None of this exists in a vacuum. You cannot have you cannot adopt a one-size-fits-all, the how-tos, 1, 2, 3 steps in administering your obligations under the FMLA, the ADA, and work comp, because individual medical conditions, restrictions, your business needs will dictate what things you can do to work with the employee on these medical issues. So FMLA, it's just some tidbits, and I'm going to go through it pretty quickly. I apologize for that. You should all have a copy of the outline. There are 75 slides. There's no way I'm going to get through 75 slides. But I did this for a reason. I wanted to provide you information in these slides. You should look at these slides. Your leave administrators, your human resource professionals, your operation management team should be look at these slides, review these slides. There's great information in them. I'm not going to be able to hit on every single one. Can't do that. But we're going to go through it, and I'm going to highlight a few slides that I really do want to emphasize before our time is done here. So intermittent medical leave, this befuddles so many employers. You know, and what employers need to know, that employees, if they are entitled, they could be entitled to intermittent leave. Now, that doesn't mean come and go as you please. You want to schedule a planned treatment so it doesn't unduly disrupt the operations of the employer. Scheduling the intermittent leave, the employer has the ability to sit down with the employee and try to work out a schedule that makes sense. And oh, by the way, if you're going to be off, if you need to take advantage of intermittent leave under the FMLA or under the ADA or because of work comp, we want to know. You got to adhere to our call-in, call-off procedures. You also, as employers, need to know that we can temporarily transfer these employees on this intermittent reduced schedule to an alternative job, which the employee is qualified and better accommodates recurring periods of leave. Now, you can't give them a job. The alternative job has to be somewhat, you know, it can't be adverse. You can't have somebody in your accounting department doing data entry, financial data entry, and then the next day say, well, because this better accommodates your need to take intermittent leave, I'm going to have you scrubbing our toilets. It doesn't work that way. Substitution of paid leave. This is important. Slide number 9. Substitution of paid leave. Remember, the employer, you can mandate employees to utilize paid leave. Okay, you can require it. Where you can't require it, it has to be mutually agreed upon. When the employee is out on FMLA leave and receiving a work comp benefit or a short-term, long-term disability benefit at the same time. In that case, the employer cannot mandate. The employer and the employee can mutually agree that while they're out on this leave, on this FMLA leave, that paid time off will be provided as well. Remember, at the end of FMLA leave, an employee can come back in equivalent position. So it keeps their job open. Remember, we cannot count FMLA leave. I'm on slide number 12. We cannot count FMLA leave against the employee under a no-fault attendance policy. That also applies to ADA. If someone needs leave as a form of accommodation, we can't also then continue to apply no-fault attendant points to that employee. And these FMLA slides, if you noticed, I cite to the actual Department of Labor regulation that is on point. So there's some authority here that you can cross-check and reference if needed. Waiver of rights. Remember, employees cannot waive their right to take FMLA leave. However, if an employee, upon termination, a separation, we always want to include in separation agreements, severance agreements, the FMLA, because an FMLA waiver is allowed. It is allowed in a severance or separation agreement, that they're voluntarily settling and releasing past FMLA claims or violations for the consideration that the employer is providing in that severance or severance agreement. Slide 14, very important, light duty. Light duty, an employee, if they accept a light duty assignment, they can always go back and say, I want my FMLA entitlement. If they're otherwise entitled to use FMLA leave, and they can use FMLA leave for a serious health condition, i.e. work comp. So if I've got a light duty program, part of my work comp, an employee can accept the light duty and change their mind and say, I just want to exhaust my FMLA leave. Now, I don't know why they would do that, because as soon as they exhaust the light duty offered and they go on FMLA, then they're going to be out of the temporary disability benefit. But stranger things have happened. So some things that you need to keep, and I'm going to go through this really fast because these are forms. And the purpose of these slides, slide 15, the employer notice obligations and notifying employees of their rights, and using the the Department of Labor 381 form and the Department of Labor 382 form and other forms and the 380 forms. I want to give note. I want to give some color to the fact that employers, you should be utilizing FMLA certification forms and notification forms that are published by the United States Department of Labor. Don't create your own. You create your own. That's a hotbed of class action litigation right now. Employers are getting into trouble. Also, just mind on slide number 16, remember, employees don't have to come to you or to HR or to their manager or to anyone and saying, you know what, I think I need to exercise my rights under FMLA. Do I have them? If I have them, I want to exercise. Employees don't do that. They're not required to do that. When an employee behaves or acts in a bizarre fashion or out of character, it's the employer's obligation, it's the supervisor's obligation to say to that employee, hey, something's not right here. Is there anything you need? Do you need anything? And it's going to be fact intensive. So when the employee is sleeping at work, they fall asleep at work, and we know that, okay, we know they're going through a divorce. We know that they're on some sort of anti-anxiety medication that can make them drowsy. All right, so they're sleeping at work. That's, short of them making their own bed, like a George Costanza thing out of Seinfeld, short of some sort of bed making and intent to sleep, that's the sort of thing, and these are real cases, where it would trigger the supervisor or manager to intervene and confront the employee to say, hey, if you need time off, you may have rights under our policies and maybe even under the law. So I'm just going through the certification, knowing that employers have the ability to mandate certificate a doctor, a medical provider, doesn't have to be a medical doctor, a medical provider must certify if the employer requires it, the condition, the need for leave with regard to FMLA. And the content of the certification is included in your slides beginning on page 21. So just kind of going through, if we have incomplete, inaccurate certification, I'm on 23, 24, we can always require authentication, clarification. And when an employee provides certification, whether it's the doctor's fault, we don't care. If they don't provide certification within 15 days of requiring it, then the employer can subject that employee to your customary attendance policies. So just to kind of move on because of the time element here, I just cannot emphasize enough to take note of the U.S. Department of Labor forms. And these slides, as you can see, slide 30, it walks you through these forms and what information is critical. What information is critical. And just some behaviors that employers need not put up with. An employee alters the doctor's certification. That's falsification of a document. I'm sure you have a policy in there. FMLA or no FMLA, they falsified a document, submitted it to the employer. It's cause for termination of employment. Failure to follow the employer's call-in requirements. Yeah, absent some sort of unusual circumstances that justify the employee's failure to comply, you better call in. Otherwise, you're subject to our attendance policies and programs. If an employee is abusing FMLA leave, if they're supposed to be in a hospital, but they're disco dancing, I mean, it's fact intensive. Maybe disco dancing is part of the therapy. I get that. But to illustrate a case and to illustrate point, honest suspicion of FMLA leave abuse is cause for appropriate, proper termination of employment. And a lot of times you'll get that, you'll get the leave abuse if it's provided to you through a third party, clarifying, confirming your suspicion. That's gravy on the icing with respect to taking the adverse action. Don't create, I mentioned this before, don't create smoking guns. This is something that your managers, your supervisors need to understand. You're not, if there's a performance review, if we note in the performance review that employee took too much leave, was away from her desk too much to attend to her doctor's appointments, you're not gonna get that case dismissed. You're just not gonna get that case dismissed. Remember, adult minor children are covered. If an employee is required to go out of state, even to Vegas with their terminally ill mother, and the terminally ill mother needs to go and gamble it away, that is protected under the FMLA. So it's just food for thought on FMLA. And just some key areas of potential legal claims regarding the leave: ambiguous policy language, doesn't define expectations as to leave rights and benefits, inconsistent policy, your leave policies, and improper actions or conduct on behalf of the supervisors and managers, saying something, doing something that would be perceived as animus against the employee trying to exercise their rights under FMLA or taking rights under FMLA. Huge areas of controversy. So now turning to the ADA. The ADA, I think the ADA is pretty easy. Once we exhaust, and as we exhaust and administer leave entitlements and rights, we always have our eye on the ADA, right? We have our eye on it. And under the ADA, we want to make sure that we're sitting down with that employee and we're trying to exhaust the interactive process. We need to document and show how we, in good faith, we made efforts to try and work with medical restrictions. We want to treat people as similar, but there's not a one-size-fits-all fits all. Medical restrictions, complications, the condition. It's going to change individual by individual. And your business circumstances, I'm sure, is going to change. You have a busy season, you have a slow season. You're in demand, you're not in demand. That's going to determine what accommodations you may be able to provide someone. The core definition of disability it's still the same definition. It's somebody who cannot perform. There's some sort of medical condition. It substantially limits a major life activity, and it prevents that employee. It could restrict that employee, not maybe prevent, restricts that employee a bit, and they can do the job. However, they can do the job. They can perform work for you with or without reasonable accommodation. The individualized, ongoing interactive process, the courts, the EEOC is requiring the following. Pick slide 47. Meet with the employee. Inquire about limitations, restrictions. Review the essential job functions. Review the job description. Job description's updated. Job description notes physical requirements of the job, medical requirements of the job, if any. Review that. Talk to and review that job description and the essential job functions together with the limitations or restrictions. Ask the employee, what are you looking for? What are you looking for? What do you need? You can communicate and you can come up with your own alternatives, because the employee is not going to give you something that you like more often than not. This is an ongoing obligation. Ongoing obligation. So things that you need to think of as the employer: can we modify the job? Can we provide tools or instruments to assist the worker? Do we have to provide a leave of absence? They've exhausted all of their leave. They have no more leave entitlements under the CBA, under the statute, under our policies, but yet the ADA says you still might need to give some leave. What if the person, they exhaust their FMLA and they only need one more week? They only need one more week. Remove barriers so that the employee may continue performing work. We talked about 100% healed, bad. We talked about rigid return to work after X time, or you're terminated, bad. And these cases highlight that. Remember, there's a trend also. There's not only does your employee is protected under the ADA for their own disability, own medical condition, but if we took adverse action, if we take adverse action against an employee, and it's linked to some sort of animus because their family member has a disability, that is a disability discrimination by association, and that is a hot trend that plays everywhere. There's a case in New York that highlights this, the Manning case on 51. We talked a little bit about sleeping on the job. This is a big issue. Plaintiff's fired after repeatedly falling asleep on the job. District court grants dismissal for the employer. The appeals court reverses, saying, hey, management, it's usually the supervisor, had noticed that the employee was suffering from a medical condition causing sleep deprivation or drowsiness, and the employer should have intervened and handled it differently, not just summarily dismissed and terminated the employee. Mandatory transfer to open jobs. So the employee can't perform their job, but they can perform another person's job that's open. That person's no longer there. There's another job opened. They're qualified for it. The employer must offer the employee a job transfer if the employee is qualified, not necessarily the most qualified. This is the law in most circuits. This was rejected by the 8th Circuit, which includes Minnesota and Iowa, but the 7th Circuit, Indiana, Illinois, Wisconsin, the 9th Circuit, other circuits have adopted this view. Common ADA pitfalls: failing to consider reinstatement rights, failure to engage in and document the interactive process, 100% healed policies, failure to consider additional leave beyond FMLA, beyond your CBA, beyond your policy as an accommodation, and creating no-fault attendance policies, return to work after X time, or you must return after the FMLA or you're terminated. Real quick, the pregnancy. Illinois, for example, just using this as an example, Illinois has come out with legislation that actually mandates accommodation for pregnancies. And it does so, and this is different because federal law does as well, thanks to Supreme Court law and EEOC guidance and some developing legal trends on a federal level. Real quick, pregnancy accommodations. In Illinois, the employee gets to pick what accommodation they want. That's different from the ADA analysis. And it's the employer's burden to show, if they deny the request, to show an undue burden. Under federal pregnancy law, the employee doesn't pick and choose, similar with the ADA. It's more of an interactive, and the employer ultimately decides what accommodation is going to be ideal. But under Illinois pregnancy, the employee gets to pick. The employee gets to pick and can reject reasonable offers by the employer. And just so you know, the pregnancy accommodations under Illinois law is in line with the Equal Employment Opportunity Commission's guidance on pregnancy accommodation in the workplace. And slide 56 gives examples of what would be considered reasonable accommodations. Remember, Illinois law, employee gets to decide, and it automatically, if the employer rejects what the employee wants, the employer has the sole burden to show it's creating an undue hardship. Undue hardship means either prohibitively expensive or prohibitively disruptive. You will never, if you ever deny someone's request for accommodation and try to claim it's prohibitively expensive, you will lose every time. You want to show it's prohibitively disruptive. And if you can tie it to safety, you're going to be in good shape. And federal law has, again, is now requiring the UPS, Young versus UPS case that came out in March 2015, slide 62, underscores that employers must accommodate employees and cannot if they give non-pregnant people with disabilities or restrictions, they've got to give the same access to those who are pregnant. It's emphasizing accommodation in the workplace. The difference between federal law and Illinois law, and this is pretty much universal throughout the United States, federal law saying, but employees just can't dictate what accommodations they want. It's that interactive process, and ultimately the employer gets to decide. Let's see. Okay. So let's turn to work comp in the time that we have left. Don't ignore the work comp. Remember, administer the work comp. We want to diminish the risk associated with retaliation. So with work comp, just some highlights. Retaliation is always possible, but risks are easily diminished through appropriate claim management, get the claim process, FMLA, leave compliance, exhaust the leave, and ADA interaction. There's nothing per se illegal when terminating an employee on work comp leave. I know the work comp people don't like to hear that. It's nothing per se illegal. Administer, manage the claim. Employees can always decline light duty and utilize FMLA rights and other leave entitlements if they're otherwise entitled to those leave rights, and acknowledge any collective bargaining or contract rights. And this is just some food for thought on managing the work comp. Slide 68 goes through the retaliation concerns. Remember, retaliation cannot be proven if the employer can articulate and prove valid non-pretextual bases for discharge. So if you implement drug-free, person gets tested for drugs in the workplace following post-accident, you consistently enforce that, you terminate, that's not retaliation. That's just you going through your drug testing policies and programs. So just completing the triangle in conclusion, exhaust all leave, administer work comp claims, engage and document in the interactive process. Don't be afraid, however, to hold employees accountable for their obligations, i.e. call-in, call-off, certification requirements. It's probably a good idea to evaluate your leave policies, your benevolent leave policies and benefit programs. And now it's time to review, update job descriptions, identify safety-sensitive positions, and actual, bona fide physical requirements, minimum physical requirements of the job. That should be noted, and that should be updated annually. With that, I'm out of time, but if anybody has questions, concerns, anything you want to run by me, I'm happy. I'm not going to charge you. I'm not going to nickel and dime. I got enough business. I want to make sure the employers get good information and they have more confidence managing medical issues in the workplace.
Jeff, thanks so much again for being here. I went ahead and sent a PDF version of the slides, so everybody should have them. If you don't, just send me an email. I'll get it to you. And I hope everybody has a great rest of their day.
And thank you. Thanks, Monique. Thanks, everybody. Appreciate the time.
Bye-bye.